If you're a UK tax resident and you're considering departing the UK for any reason, lifestyle, tax, politics, ideals you do not agree with, and you're wondering how you should wind up your connection with the UK in the most tax efficient way, then this topic might be useful to you. Today, we're going to be talking about general rules that surround the UK tax non-residency and what is required of you to comply with in order to achieve that. My name is Jelena. I'm a strategy manager here at Nomad Capitalist, and we help 7- and 8-figure entrepreneurs go where they treat it best. It is important to remember that there are some general rules applicable to the majority of leavers, as we will call them, or people who want to depart the UK for tax purposes. And then there are specific rules or laws that need to be taken into consideration separately on a case-to-case basis, which is something we would recommend contacting an expert to help you with. Now, when it comes to the general rules regarding tax on residence, they are not that simple and can sometimes be confusing. In general, they can be divided into 3 main tests. The first one is the automatic non-resident test. The second one is the automatic resident test. And the third one is a sufficient ties test. Now, these tests are looked one after the other. So we're going to go one by one. The first one is the automatic non-resident test. This means you meet the criteria for being a de facto non-resident. You are automatically a non-resident if you fall under any of the conditions that I'm going to mention here. So first, you were not a resident in the UK in 3 tax years and you're present in the UK for fewer than 46 days in the current tax year. Or you were a resident in the UK in 1 or more of the previous 3 tax years and you are present in the UK for fewer than 16 days in the current tax year. Or the third option is that you carry out full-time work abroad. That means that you are present in the UK for fewer than 91 days in the tax year and you do not spend more than 30 days in the UK working in a single tax year. If you do not fall within the first test, you would not necessarily be deemed a UK tax resident. You would instead need to consider the second test or the third part of the test. The second test is the automatic resident test. Now, leavers will always be taxed as residents if they spend 183 days or more in the UK in a full tax year. However, this 183-day rule is not the only test. Even if you're physically present in the UK for fewer than 183 days in a tax year, it is still possible for you to be a resident in the UK. Now, you will be deemed automatically a resident for the tax year under the second test if you meet any of the conditions I'm going to be mentioning now. First, you are present in the UK for 183 days or more in a tax year. The second one is that you have only one home and that home is in the UK. And the third test here under the part 2 is that you carry out full-time work in the UK. Now, if you do not meet any of the conditions in the second test, you will not necessarily be a non-resident. Instead, you will need to consider the third test, which is a sufficient ties test. For most leavers, the number of ties you maintain in the United Kingdom will determine your tax resident status. Generally, you may maintain some ties to the UK based on the amount of time you spend there in any given tax year. The less time you spend in the UK, the more likely you will be deemed a tax non-resident. Now, the UK ties I'm talking about here are, first of all, your family. So your spouse or your civil partner or common law or minor children have to accompany you outside of the UK. The second one is the accommodation. You should not have available accommodation to you in the UK and make use of it during the tax year. The third part is substantial work in the UK. So if you have employment or self-employment in the UK, which is defined as 40 work days or more than 3 hours in the tax year, you may fail this test. And then also what is looked at is UK presence in previous years. So this comes down to whether you have spent more than 90 days in the UK in either of the previous 2 tax years. Then also what is looked at is if you have spent more time in the UK than in any other country. So if you spend more days in the UK in the tax year than in any other single country, you may fail this test. Now, these tax ties can additionally include UK bank accounts, credit cards that are less of an issue, brokerage accounts, UK insurance policies, UK registered cars, boats, motorcycles, other vehicles, and then also storage facilities or mailbox services in the UK, in addition like phone contracts or other communication services and subscriptions that you may have. So to become a tax non-resident, you must demonstrate the intent to permanently leave the UK. Again, this does not mean that you can never return, as you are obviously free to change your mind later, but your intent at the time of departure needs to be of permanent nature and cannot be seen as a vacation or a gap year by the HMRC. Now, generally speaking, it is usually advisable to be a non-resident for at least 5 years before returning to ensure you are not assessed on tax on previous earnings or gains. As each situation is different, we recommend seeking professional advice if you plan on leaving the UK for tax purposes. Now, if you have a company in the UK, there are generally a few options available to you and maybe some additional ones based on your particular situation. But some general options that exist when departing the UK and wanting to address your company as well, first of all, is leave the UK company dormant. So you can wind it down by taking dividends or going to liquidation and treat it as a capital gain. If you do this as a non-resident, it will be doable for you to get money tax-free, either in form of dividends or capital gains. The second option is to keep the UK company running in the UK. So if this were the case, you should not be a director or otherwise employed in the company. You should just be a shareholder. You could additionally take dividends as a shareholder that will be after tax in the UK and will not affect your tax status in the UK. Obviously, depending on where you go from the UK, those dividends might be taxed in that country. So you need to be careful about that as well. Now, if in addition to your UK company, you also establish a foreign company, what you could potentially do is invoice your UK company for your services from your offshore company. However, in this case, it is important to pay attention to how much you can invoice the company. So you want to be very certain that what you invoice is a fair amount. You need to make sure that that amount you invoice is the proper market value for services provided, because if you invoice too much, the HMRC might challenge that if they find it suspicious. And in that case, you need to have a solid justification supporting the payments. So you cannot simply just transfer millions of dollars from a UK company to a foreign company. It really needs to be on a fair market value. So for the tax on residence purposes, be aware that the UK counts the number of days you're physically present at midnight as a day. Now, there are exceptions and special circumstances which can change this, but you should not rely on those in our opinion. Furthermore, we recommend leaving yourself a buffer in the number of days to ensure that you don't have any issues with the HMRC. Now, one good thing about the UK as opposed to some other countries like Australia and Canada is that there is no exit tax for individuals. For companies, there are taxes to be paid before the liquidation, but there aren't exit taxes as such for individuals. For those who invest in cryptocurrencies or other commodities as stocks, ETFs, options, or similar, and hold them in their personal name, there is no exit tax payable, which is definitely good news. However, if this is done in the name of a company, that can trigger additional taxes, but generally not in case of a physical person. So when comparing the UK exit with some other countries, it can be said that this is somewhat easier. There's no exit tax for individuals, and there are some tests that can be easier to satisfy for tax on residents. There's no dividend withholding tax for non-residents, and there can be tax-favorable ways to close down or transfer your business offshore depending on your exact situation. As I mentioned, some of these things are really general rules applicable to the majority of people. But if you have a more complex situation or a more robust structure in the UK, we recommend contacting a specialist. Now, if you're interested to find out more about this process and want to see how it will apply to you, you can apply to work with us on our website page, and we will be happy to help you.